The words came out measured and precise, the way one might discuss a real estate closing rather than the terms of belonging in a family. My mother-in-law sat at the head of the long table in the sunroom, the afternoon light catching on the crystal water glasses no one had touched. She slid a fresh folder across the polished surface toward me and said the arrangement we had relied on for the past 2 years needed updating. If I wanted to remain in the compound and continue participating in the family's holdings, I would sign the new pages by the end of the week. Otherwise, the existing structure would be enforced to its fullest extent, and I would be expected to make other living arrangements. If you have ever heard someone you called family explain exactly how little room there is for you, unless you sign away another piece of yourself, you already know the particular quiet that followed those sentences. I did not raise my voice. I did not ask why the terms had changed so suddenly. I simply picked up the folder, opened it, and scanned the first page while she watched me with the same polite expression she had worn at every holiday dinner since I married her son. The new document referenced the original notarized agreement I had signed 2 years earlier, the one presented to me as routine protection for everyone involved. That earlier paper had seemed straightforward at the time, a way to keep certain investments aligned with the family's long-term plans, while I contributed my own capital and analysis to the real estate projects we were developing inside the gated walls of Briarwood Estates. I had read every clause then. I had asked the questions that seemed reasonable. The answers had all been reassuring. Now the new pages made clear that the original agreement contained language allowing for administrative adjustments at the discretion of the primary trustee. The primary trustee, according to the signature block on the old document, was my mother-in-law. I closed the folder without signing anything and set it back on the table between us. My sister-in-law, who had been sitting to the left of her mother the entire time, finally spoke. She mentioned that some people simply were not raised with the same understanding of legacy and obligation. She said the family had been patient, but patience had limits when one person's history created ongoing risk for the rest of them. The comment landed lightly, almost as an afterthought, yet it carried the weight of every quiet conversation I had pretended not to overhear over the past year. She did not need to name the details of my childhood out loud. The implication was enough. The financial troubles my own parents had navigated when I was younger, the years I had worked extra jobs while finishing school, the fact that I had arrived in this marriage without the same inherited buffers the Langford name carried. Those facts had apparently become leverage. I looked at my husband, who sat across from me and had not spoken since the folder appeared. His eyes stayed on the table. That silence was its own answer. I stood, thanked them for their time, and walked out of the sunroom into the wide hallway that led back toward the smaller residence we occupied on the edge of the compound. The gate at the main entrance was visible through the front windows, a reminder that every boundary here was deliberate. Later that evening, I sat at the desk in the small office I kept in our residence and opened the digital copy of the original notarized agreement I had saved on my personal drive. I read it again more slowly this time, paying attention to the sections that had seemed standard 2 years earlier. One clause in particular now stood out. Any material change in the contributing party's personal circumstances could trigger a review of asset allocation. The definition of material change was left to the trustee's reasonable judgment. I had not considered at 25 how easily that judgment could shift once the signatures were dry. The next morning, I drove into Charlotte for a scheduled meeting at the firm, where I still kept a part-time consulting role separate from the family projects. Marcus Hale was already in the conference room when I arrived. He had been reviewing the latest cash flow projections for one of the Briarwood adjacent developments we had been tracking externally. He mentioned almost in passing that a couple of the transfer records from the family trust looked inconsistent with the timelines we had discussed last quarter. He said he would pull the full audit trail and send it over before the end of the day. I thanked him and kept my expression neutral, the same way I had kept it in the sunroom. By the time I returned to the compound that afternoon, my sister-in-law was waiting near the smaller residence's front steps. She asked whether I had given any more thought to the conversation from the day before. She said the family was only trying to protect its own interests and that sometimes protection required difficult conversations. She added that people who grew up watching their parents lose everything tended to make unpredictable decisions with money. The sentence was delivered with the same light tone she used when discussing the weather at neighborhood events. I told her I was still reviewing the documents and would respond when I had finished. She smiled and said she hoped I would make the right choice for everyone involved. That night, I sat with the printed copy of the original agreement under the desk lamp and traced the notary's seal with one finger. The signature on the trustee line belonged to my mother in law. The signature on the contributing party line belonged to me. Between those two lines sat language that had looked protective on first reading and now looked like a lever that could be pulled at any moment. The trustee decided the circumstances had changed. I had signed it because I believed the marriage and the move into the compound represented a shared future, not a conditional one. The paper in front of me suggested the condition had always been there waiting. I put the pages back into their folder and placed the folder in the bottom drawer of the desk. Then I opened my work email and found the message from Marcus Hale. He had attached the audit trail he mentioned earlier. The subject line was simple discrepancies worth a second look. I did not open the attachment that night. I turned off the desk lamp, walked through the quiet rooms of the residence, and stood at the window that faced the main house where the rest of the family lived. The lights were still on in the sunroom. I watched them for a while without moving closer to the glass. The next morning, I called Marcus Hale and asked him to walk me through the numbers in person. I told him I wanted to understand every transfer that had moved through the trust since the original agreement was signed. He agreed without asking why. That was the first concrete step I took after the ultimatum. Everything before that moment had been observation. Everything after it would be verification. The morning after I spoke with Marcus Hale, I met him at a small conference room in an office building, 2 exits down the interstate from the compound. He had printed the transfer records rather than sending them electronically. He laid the pages out in chronological order across the table and pointed to the first one that did not match any project timeline we had discussed in the previous quarter. The amount had moved from an account tied to the original notarized agreement into a holding entity whose sole signatory was listed under my mother-in-law's name. 3 subsequent transfers followed the same pattern, each one described in the memo line as administrative reallocation for family liquidity. None of the reallocated funds appeared in the development budgets Marcus and I had been tracking together. He did not ask why I needed the details. He simply circled the dates and the destination accounts in red and said the pattern had begun approximately 6 months after the original agreement was signed. I took the pages, thanked him for the clarity, and drove back toward the gated entrance without stopping at any of the shops or cafes along the way. The guard at the gate nodded as he always did. I nodded back. Inside the smaller residence, I placed the printed records in the same bottom drawer that already held the copy of the notarized agreement. My sister-in-law appeared at the door 2 hours later. She said she had been thinking about our earlier conversation and wanted to make sure I understood the family's position. She mentioned that people who had watched their own parents lose control of their finances often developed habits of secrecy around money. She said the family had noticed I had been asking questions outside the usual channels. The statement was not phrased as an accusation. It was offered as a concerned observation, the kind one might make about a neighbor's landscaping. She added that the new document on the table in the sunroom was simply the formal way of addressing those habits before they created larger problems for everyone. I told her I was still reviewing the original terms and would respond once I had finished. She left without pressing further. After the door closed, I returned to the desk and opened the folder again. This time, I read the clause that defined material change in personal circumstances a second time. The language was broad enough to include any external inquiry into the trust's activity. The trustee retained sole discretion to determine whether such an inquiry constituted a risk. I made a note of the exact wording on a separate pad. That evening, my mother-in-law sent a short message through the internal compound messaging system the family used for household matters. The message stated that the review process referenced in the new document would begin automatically if the signature pages were not returned by Friday at noon. She added that she hoped I would choose the option that preserved harmony. The tone was the same measured tone she had used in the sunroom. There was no follow-up question and no request for a meeting. I spent the next day cross-referencing the transfer dates Marcus had circled against the project files I kept on my work laptop. Several of the reallocated amounts aligned with periods when the main house had undertaken renovations and when my sister-in-law had expanded a separate consulting arrangement she maintained outside the family developments. None of the amounts had been reported back into the joint project ledgers. The original agreement contained no requirement that the trustee provide an accounting to the contributing party unless the contributing party formally requested one in writing. I had never submitted such a request until now. On Thursday morning, I received another message, this one from my sister-in-law. It referenced a conversation she claimed to have had with an old acquaintance of mine from before the marriage. The acquaintance had apparently mentioned the period when my parents' business had been restructured and how I had taken on additional work to help stabilize their situation. My sister-in-law wrote that she found the story instructive because it illustrated why some people required more structured oversight than others. She closed by saying she looked forward to seeing the signed pages on Friday. I did not reply. Instead, I drove back to the same office building where I had met Marcus Hale. He was available for a second conversation. This time I asked him to pull any internal notes or correspondence attached to the trust transfers. He returned 20 minutes later with a short stack of emails that had been archived in the development company's shared drive. One of the emails sent from my mother-in-law's address to the family's outside attorney 6 months earlier referenced the contributing party's documented pattern of financial exposure originating in her family of origin as a justification for moving certain liquid assets into more controlled structures. The phrase documented pattern was not defined further in the email. The attorney had replied with a single line confirming that the language in the original agreement permitted such adjustments at the trustee's discretion. I left the printed emails with Marcus and asked him to keep a second copy in his own files. He agreed. On the drive back to the compound, I stopped once at a copy shop and had the entire original notarized agreement scanned and saved to a secure cloud folder that was not linked to any family account. I also scanned the new document that had been presented in the sunroom. The comparison showed that the new pages added a requirement that any external review of the trust by the contributing party would automatically trigger a full audit at the contributing party's expense. The audit would be conducted by an accounting firm selected by the trustee. Friday morning arrived without any additional messages. I placed both the original agreement and the new document into a single folder and carried it with me when I left the smaller residence. I did not go to the sunroom. I drove instead to a bank branch outside the compound, where I maintained a single personal account that had never been folded into the trust. I requested a notarized copy of the account's activity for the previous 24 months. The teller processed the request without comment. I returned to the compound with the new notarized bank records in the same folder as the agreements. My mother-in-law was standing on the front steps of the smaller residence when I pulled into the driveway. She said the deadline had passed and that the review process had therefore begun. She asked whether I intended to sign the new document or whether I preferred to proceed under the terms of the original agreement as written. Her voice remained even. She did not raise it when I told her I would be providing a written response by the end of the following week. She simply nodded once and said she hoped the response would reflect a clear understanding of the family's expectations. After she walked back toward the main house, I carried the folder inside and placed it on the desk. I opened the scanned copy of the original agreement on my laptop and read the trustee discretion clause a third time. The language had not changed since the first reading. What had changed was the surrounding evidence that the discretion had already been exercised repeatedly and without notice. The childhood reference in my sister in law's message and the email to the attorney now sat alongside the transfer records as a single coherent record. I saved the file under a new name and closed the laptop. The compound felt quieter than usual that evening. No messages arrived through the internal system. No one knocked on the door of the smaller residence. I sat at the desk with the folder in front of me and the bank records beside it. The next step would require an outside review of the full chain of transfers and the exact scope of the trustee's authority under the original document. Marcus Hale had already offered to connect me with an independent forensic accountant who worked with his firm on external audits. I had not yet accepted the offer. Accepting it would make the inquiry formal and would almost certainly accelerate whatever process my mother in law had described as already underway. I left the folder on the desk and walked through the residence one more time before turning off the lights. The gate at the main entrance was visible from the front windows, the same view I had watched on the night after the ultimatum. The lights in the sunroom of the main house were on again. I did not move closer to the glass. I simply noted the fact and continued to the bedroom. The decision about the independent review could wait until morning. The folder on the desk would still be there when I returned to it. The next morning, I called Marcus Hale and accepted the introduction to the forensic accountant his firm used for external reviews. We met at the same office building outside the compound. The accountant reviewed the transfer records, the original notarized agreement, the internal email referencing my family background, and the bank statements I had obtained. He confirmed that the reallocation language had been applied repeatedly to move funds from accounts tied to my pre-marriage capital and salary contributions into structures controlled exclusively by the trustee. He also noted that the justification language in the email created a documented pattern that could be examined under the trust's own governing documents if an external party ever requested formal accounting. I thanked both men and asked Marcus to retain copies of everything in his firm's secure files. I did not ask him to take any further action. The review itself was the action. I returned to the compound, placed the new folder of findings alongside the original documents, and waited. My mother-in-law requested a meeting in the sunroom that afternoon. My sister-in-law was already seated when I arrived. My husband sat in the same chair he had occupied during the first conversation. My father-in-law was present as well, though he remained silent for most of the exchange. My mother-in-law began by noting that the review process referenced in the new document had now formally commenced. She asked whether I had prepared the signed pages or whether I intended to proceed under the original terms as written. Her tone remained even and businesslike. I opened the folder I brought and placed the independent review summary on the table. I did not raise my voice. I simply stated that the transfers documented in the summary appeared inconsistent with the project timelines, and that the internal justification referencing my family background had been prepared without my knowledge or consent. I added that I would not be signing the new document and that any further communication regarding the trust would need to occur through legal counsel. My sister-in-law responded first. She said the family had only been protecting itself from patterns that had already proven costly in other situations. She referenced the same childhood details again this time, stating outright that a person who had grown up inside financial instability could not be expected to manage shared assets with the same discipline the family required. The statement was delivered as fact rather than opinion. My mother-in-law nodded once and said the review would now include a full accounting of all contributions and reallocations. She added that the cost of that accounting would be deducted from the contributing party's share under the original agreement's terms. She did not raise her voice either. The conversation ended when I stood and said I would be vacating the smaller residence by the end of the week. No one asked me to reconsider. My father-in-law spoke only after the others had left the room. He asked if I would walk with him to the front steps. His voice was quieter than the others had been. He said the original agreement had been presented to him as a temporary measure to simplify certain tax and liquidity questions at the time of the marriage. He had not reviewed every clause himself. He said he had trusted the judgment of the person who prepared it. He did not apologize. He simply stated that he had not anticipated how the discretion clause would be applied once the signatures were in place. I thanked him for the information and told him I would not be returning to the compound after I left. I spent the next 3 days packing what belonged to me and arranging storage for the items I did not need immediately. I did not announce my plans to anyone inside the main house. On the morning I loaded the last boxes into the car, I received a message from Lila Bennett, the friend I had known since before the marriage. She wrote that she had heard concerns from people inside the compound about my handling of shared responsibilities, and that she thought it best if we took some space from each other for a while. She did not ask for my side of anything. I replied with a single sentence, acknowledging the message and wishing her well. I did not send any further messages. The gate closed behind me when I drove out that afternoon. I did not look back at the sunroom windows. I had already arranged a short-term apartment in Charlotte through a relocation service that did not require family references. The lease was in my name only. The first night I sat at the small kitchen table with the folder of documents in front of me and the independent review summary on top. I read the summary once more, then closed the folder and placed it in a drawer I would not open again for several weeks. In the months that followed, the trust underwent the accounting my mother-in-law had described. The process revealed reallocations that required correction under the original agreement's own language. The corrections were handled quietly between the family's attorneys and the external reviewers. I received no further messages from anyone inside the compound. My husband did not contact me to discuss the separation that became necessary once I was no longer residing there. I did not initiate contact either. The isolation was not dramatic. It was the absence of invitations, the absence of updates, the absence of any remaining expectation that I would continue to absorb the cost of belonging on terms that had never been equal. I released the version of myself that had kept trying to prove the childhood details did not define my judgment. That version had signed the original agreement because she believed documentation created safety. The version that remained understood that safety required the ability to walk away when the documentation itself became the mechanism of control. I kept working with Marcus Hale on the external projects that had never been folded into the trust. The work itself did not change. What changed was that I no longer needed to translate every decision through the lens of family harmony. The quiet that followed was not peace in the sense of resolution. It was the absence of the constant calculation required to stay inside a structure that had always treated my presence as conditional. I did not miss the calculation. Some days I still wondered whether a different set of signatures at the beginning would have produced a different ending. The answer did not matter. The documents had been signed. The discretion had been exercised. The only remaining choice was whether to keep participating in the structure that had been built around that discretion. I had already made that choice when I drove through the gate for the last time. Thank you for listening to my story. What was the moment that made you realize the cost of staying was higher than the cost of leaving? Let me know in the comments.